Good day. I'm glad to see you back here again. Today we continue our lecture on Nigerian legal method. In the previous lecture, we looked at what research method is all about and the essence or importance of studying research methodology for Nigerian law students. In this second lecture, we dive into the core elements of the course, and we start by understanding what law is about. As a law student or anybody that has interest in the Nigerian legal method, the first element or concept that you should familiarize yourself with is law. Law itself means different things to different people because across different fields, law has been applied, conceptualized, and defined in different ways. So, for instance, in the field of physics, we have the law of gravity, whereby whatever goes up must surely come down. So different fields, different areas of studies, different professions have their own definition of what they at least conceptualized to be law. So there is no universal definition of law per se. So while numerous efforts have been made towards attaining a universally acceptable definition of law, such universally acceptable definition of law doesn't still exist because different fields consider law to mean different things to them. Okay, so however, attempts have been made to develop a working definition, as the universal definition of law is still not attainable. So as law students, we are going to define, conceptualize law in relation to the Nigerian legal method. Okay, so one of the pioneers of legal study in Nigeria is Professor A.O. Obilade, and he defined law to imply any body of rules that govern human behavior. Okay, for these rules to become law, they have to have an element of obligation attached to it. That is, what someone is expected to do or the punishment that is applicable in the event that the person deviates from doing what is expected of him or her. In a situation where there is no such attached obligation, one could just say that what you have is just mere rules of morality. Okay, so if for instance an armed robber comes into your house, makes away with your properties, and there is no attached obligation as to the punishment that the person must receive for such an act, then it becomes mere rules of morality. That implies that anybody can just walk into your house any day and just misbehave as he or she pleases. But because there are rules attached to there are obligations, consequences attached to such behavior, it becomes paramount to say that when one is engaging in criminality, he or she expects to be punished if caught. Okay, that element of coerciveness, that element of obligation is what desists them from acting in certain ways. Okay, so for a rule to be considered as a law, there must be an attached obligation. There must be consequence for either disobedience or acting against the established rule. Okay, so going further, we look at the nature of law. What are those elements that define, that encompass the law as a concept? The first is compulsiveness or coercive nature in character. That is to say, laws are made to force people to act in certain ways, and if they don't act in such ways, then they should expect the consequences that comes with disobedience. So it comes with an element of coerciveness. It forces us, or it forces the people, or it forces the society to behave in certain way. So if you take the law of the Christians, for instance, the 10 Commandments, it says that you have to obey the 10 Commandments, and what is the expected benefit? You go to heaven. Then what is the consequence or punishment for disobedience? You go to hell. So that coercive nature, that compulsive nature is the main element that makes it to be law. Because when you do the right thing, you are expected to benefit from your action. And when you do the wrong thing, you are also expected to be punished for your wrong act. Okay? The second element is that law is dynamic and organic. It doesn't stay one place. It is not stagnant. It changes with change in the society. Okay, we take Nigeria for instance. Previously, we had nothing like the Electoral Act, which embodied the beavers and the relaying of collected data or election results from the polling unit straight to INEC database. It came in as the need arises. It came in as advances in technologies became eminent. Okay, the cyber crime we have today, back in the days, they weren't all that an issue. So the laws that regulate such acts came in as these changes we are experiencing in the society. So by being dynamic and organic in nature, we simply imply that law changes with new developments, new trends in the society. So whatever direction the society is moving, the law of the land will also move with it to ensure that it protects everybody, to ensure that it serves the basic interests of everybody in the society. Okay, so the third element is that it suppresses deviant behavior. Of course, if the law is compulsive, that is to say it forces you to act a certain way or be punished, and dynamic, that is to say it changes with time or changes that are experienced in the society, definitely it becomes a tool for suppressing a deviant behavior. So if new laws are made, you are also expected to abide by it, and if you don't abide by it, there will be punishments. So the presence of that coerciveness, the presence of that enforceability, the presence of that punishment that comes with disobedience is what makes it able to suppress deviant behavior. So people tend to act in the right way because they don't want to be punished for their wrong acts. Okay, so these are the three main elements or core concepts that define the nature of law. For it to be law, it must be compulsive, it must be dynamic, and it must be able to suppress deviant behaviors in the society. Are you getting the point? Okay, so going further, we look at the sociology of law. That is the relationship between law and sociology. It is a common saying that no man is an island and we all interact with each other. But these interactions bleed conflicts. They cause issues here and there. So to ensure that we can all coexist, the law is there to correct and address the conflicting issues when they arise. Okay, so you made a transaction with someone, and in the process of the transaction, the person did not complete his own part of the obligation, although he is trying to compel you to complete your own part. What are the provisions, what are the protections that the law offers to you, or that the law offers to both parties, to make sure that nobody is taking advantage of each other? That is the sociology of law. Okay, so essentially law is based on socially acceptable norms, principles, and cultures. That is why what is law here in Nigeria might not be law in Ghana. What is law in Ghana might not be law in Nigeria. Even in Nigeria here, what is law here in the East might not be law in the North. That is why we have the penal code for the North and the criminal code for the South. Okay, drinking of alcohol might not be an issue here in the Southeast, but it could be in the North, in Sokoto, for instance, and so on and so forth. So sociology of law simply imply that in the process of forming law, the law itself has to also consider the values, principles, norms, and culture of the people that it aims to govern. If not, there will be anarchy, because people will not obey laws that they feel is not aligned with their own principles, their own cultural definitions. Okay, so any law that is being made for a society, like the legal people will always say, should not be repugnant to social policy. It should always consider the interests of the people that such laws are being made for. Okay, that is the only way one can be able to ensure obedience to such laws. Okay, then we go down to the philosophy of law. In the philosophy of law, we are trying to say that law is focused on what? Addressing human needs and wants. And it should practically command what is possible. Just like we said, it should consider the interests of the people that it is being made for. For it to be obeyed, for people to abide by the law must represent their own personal interests. It must be aligned with their norms and the existing cultures for it to be accepted. If it is different, then there could be possible anarchy to it. Okay, so let's say one day someone wakes up and puts a ban on drinking of gare or something like that. A staple food in Nigeria. What is the possibility that such law will be obeyed? What is the possibility that people will compel themselves to accept such law? Okay, so in the absence of that philosophy, in the absence of that consideration, obedience becomes more or less impossible, because it is against the basic will, the basic norm, the basic culture, this basic acceptability of the people that the law is made for. Okay, so for it to be possible, we have to make sure that the philosophy of developing a law is aligned with the need for it to merge with the social acceptable norms, principles, standards, and the culture of the people that such laws are being made for. Okay, this is because lex non cogit are there impossibilia. The law does not command what is not possible. The law does not command the impossible. Are you getting the point? So for a law to be made for anybody or any group of people or any society, it must be one that is possible. It must be something that the people can do. It must be something that the people will accept to do. Okay, so that is the basic philosophy of law. So today we have been able to define law. We have been able to look at the nature of law. We have also seen the sociology of law, and now the philosophy of law. So that ends our lecture for today, and we will continue next time. Thank you for being around, and we hope to continue seeing you around as we complete the entire course or curriculum in legal as it relates to legal method in Nigeria. Don't forget to like and share, and we hope to see you back very soon. Thank you and have a wonderful day.